Good morning, everybody. My name's Charlie Banner QC of Landmark Chambers. I'm chairing today's seminar and welcome. We've still got a few people joining us as I speak, but the counter is currently approaching 600, which is quite astounding, and a vindication of the Zoom technology, which is now, of course, taking over our lives. Thank you all very much indeed for joining us today. We're really grateful. May I first of all say I hope you, your colleagues and your families are staying well during the current challenging times. We hope you'll find today's discussion on planning in the COVID-19 crisis to be useful and informative. I'm going to start with a few housekeeping points whilst the attendee counter continues to increase. Firstly, your microphone's all automatically muted, so you won't need to adjust your settings, and your screens are also not visible to us, so it doesn't matter if you're in your pajamas. Very much welcome questions throughout the session. There's a Q&A feature at the bottom of the screen. Those of you who've already familiarised yourself with Zoom will probably be familiar with that too. Please submit the questions you may have in the Q&A section. We'll deal with all questions at the end, that's going to be a bit more straightforward. If we can't deal with anybody's questions due to time, then we'll follow up directly with you after the event, and please indeed follow directly up with us after the event if any questions or comments occur to you after we've concluded the seminar. If at any stage you lose your connection, simply rejoin the meeting by clicking on the link once more, and that should bring you back in. We will circulate the slides shortly after the presentation. I can't say precisely when, but hopefully today. Some of the slides in particular, certainly mine, have some hyperlinks in. I'm not going to click on those hyperlinks during the course of the presentation, but just to alert you that there are hyperlinks there to some of the more useful documents. Let us begin. Now, so first of all, let me introduce today's speakers. I'm going to speak first of all on the subject of planning appeals. What's PINS currently doing to keep the planning appeal system flowing, and what options are there to improve that during the time where we have to socially distance. Richard Turney is then going to speak on the practice of the planning court, the division of the High Court that deals with planning and environmental challenges. Then Anjoli Foster will speak on the subject of how to keep planning permission alive during the COVID-19 crisis. And finally, Matt Henderson will discuss the issues relating to shops, restaurants, cafes and drinking establishments during the COVID-19 crisis. So first of all, planning appeals. I'm going to start with what PIN's current position is. So following the announcement of the so-called lockdown a few days ago by the Prime Minister, PIN's updated their guidance, and it's in the terms that I quote on this slide. What they say is they've closed their offices and instructed all staff, including inspectors, not to travel for work. So as a result of that, PIN's position is until the situation changes, there will be no site visits, even unaccompanied site visits, no hearings or inquiries. They then say they're considering if work can progress in the following ways. In relation to site visits, they're thinking about whether there are types of cases that can proceed without undertaking a visit. No mention here about something that local authorities are considering, which is are there any other technical ways of doing a site visit, such as drones, etc. Inquiries and hearings, what PIN says this is we are considering whether it might be feasible to use tech solutions to enable events to proceed whilst ensuring fairness for all parties, especially third parties, given their public events. And then they go on to say that some cases they might consider for written reps. So they're considering using tech solutions subject to fairness and ensuring that the event can remain public. That's the current stated stance of the Inspectorate. In practice, some real examples, some of these are my own cases, some of these are colleagues. So a colleague of mine has had an inquiry that was due to take place in May, adjourned indefinitely before the deadlines for exchange of proofs and without exchange of proofs. So that inquiry has gone on hold. I've had an inquiry which was due to take place for 3 weeks in April, relisted for 3 weeks at the end of September. It's not entirely clear whether that timeline is due to the inspector's availability or a reflection that the inspectorate don't see inquiries coming back up until the autumn. I'm also involved in a written reps appeal where the exchange of representations was completed mid-January. We were waiting the inspector to do his unaccompanied site visit. We've been told that that won't happen and there will now be a considerable delay because the site visit isn't possible. All of this raises a number of questions in terms of the implications for housing supply and housing delivery, given a significant proportion of housing supply in a number of authorities is derived from appeal-related work, which would ordinarily be the subject of inquiries or hearings. In turn, that may lead to some authorities seeking potentially a relaxation of the normal policy consequences of a lack of a 5-year supply. Delivery of infrastructure, something which prior to the COVID-19 crisis was a key priority for the government in the economic programme that it had and doubtless will be next year. I'm focusing more on Section 78 appeals rather than EIPs and the DCO process, but similar considerations apply, albeit in a different context there. In relation to the economic recovery next year and beyond, clearly if there is a considerable backlog of major consenting decisions which could have implications for economic recovery, that will frustrate the objective of making as swift a recovery as possible. Also, what are the resource implications, human resource and other resource implications of having a considerable backlog to work through? And related to all of that is the impact on the objectives of the Roseroll review of the inquiry system to speed up and make more efficient the planning appeals process. So there are some serious issues that the current position raises. The same week as the inspectorate's statement, or a few days before, the Lord Chief Justice made a statement in relation to the practice of the civil courts of England and Wales. And the Lord Chief Justice says the default position in all civil jurisdictions is that hearings would proceed with at least one party attending remotely. He goes on to say that in light of the truly exceptional challenges of the current crisis, fourth line down, we will all need to recognise we'll be using tech to conduct business, which even a month ago would have been unthinkable. So a recognition by the Lord Chief Justice that we need to really change our game quite radically and quite quickly. Final hearings and hearings with contested evidence very shortly will inevitably be conducted using tech. Otherwise, there'll be no hearings. Access to justice will become a mirage. Even now, we have to be thinking about the inevitable backlogs, delays the building in the system will build to an intolerable level if too much business is simply adjourned. So the court taking the view that there's a need without delay to switch to reliance on the kind of tech that simply would just be thinkable even a month ago in order to avoid a standstill in the justice system. Turning to the planning court specifically, and Richard's going to deal with this in more detail in a few minutes, the planning court have already heard significant planning cases by phone and video link this week, as indeed has the Court of Appeal. There's a hyperlink here to a blog by my colleagues Chris Katkowski and Kate Ollie describing their experience of one such hearing. I've also included a link to a Supreme Court video hearing from last week, the Supreme Court itself having embraced video technology. In relation to local authorities, as many of you will know, the Coronavirus Act 2020, Section 78, and regulations which are imminent will allow local authority as to hold their meetings by remote conferencing. There was a very useful circular earlier this morning by my friends at ICENI who looked at the extent to which remote conferencing had been taken up by London local authorities, and to some extent or other, all London local authorities have already embraced remote conferencing, and I'll indicate in a moment the government's stance on that in a moment. So what that means is we will shortly be in a position where appeals to the planning inspectorate are from at least some decision makers that themselves use remote conferencing, decisions made by remote conferencing, and onward appeals or applications to the High Court and beyond from PINS will use remote conferencing in the planning court. However, stuck between those two bookends is PINS, which is still considering whether it might be feasible to use technological solutions to enable events to proceed whilst ensuring fairness, given these are public events. The Chief Planner, Steve Quartermain, who I'm sure didn't envisage that his final few days in this role would be defined by the current crisis, he wrote to local authorities the day after the inspectorant's guidance, as I quoted, was published. And he made clear that in the government's view, they expected local authorities to take an innovative approach in order to allow the system to function as far as was possible, using all options available to continue their service. He goes on to say in the second paragraph, urging authorities to explore every opportunity to use tech, and then indicating the government's intention to introduce legislation, which is now in the form of Section 78 of the Coronavirus Act, to allow meetings at local authorities to be held virtually. So a clear exhortation to local authorities from central government to embrace tech to the fullest extent possible to keep the wheels going round. There's then in the same letter, a reference to the inspectorant's guidance, and he says this: PINS will keep its guidance under review, which could change at short notice to reflect the government's wider advice. And I don't think I'm being too much of a black letter lawyer to reach the conclusion that that's an indication that the government feels that PINS' approach currently does not reflect the wider advice given to local authorities. So that's where we are. What could a phone or video hearing involve if it does happen? In broad terms, certainly the form that I have in mind, which is broadly consistent with the model that I've described in the past as Written Reps Plus, it's also been called a virtual inquiry in a very helpful paper produced by King's Chambers No. 5, which has now been taken forward with PIBA, the barristers' representative body to PINS. Broadly speaking, it could involve the following: a procedure which is offered to the parties to an appeal that's going to otherwise would have been heard by an inquiry or hearing as an alternative to a lengthy postponement. PINS would seek representations from the parties as to whether that virtual procedure was appropriate. And then two potential models. One, either the inquiry proceeds in a virtual way if all the main parties agree to that procedure, or alternatively, rather than giving each party essentially a veto, another way of doing it would be for PINS to make a decision as to whether it's appropriate, having regard to the representations made and having regard to published criteria, much as the inspectorate does already when considering whether a case should proceed by way of written reps, a hearing or inquiry. I then envisage that the inspector would identify the main issues from the written material, which would either already have been submitted or would be provided subsequently. There would then be issue-specific video, or if video is not possible, phone sessions. In other words, a topic-based inquiry on those main issues. I think issue-specific hearings would be easier to do in a virtual way, and then the participation could be invited for each issue-specific session from all those who've made representations on that issue. There'd then be sessions with third parties, Section 106 and conditions. Closing statements and indeed opening submissions could be done either by a written exchange or done orally through remote conferencing. It really, to my mind, doesn't matter much. And there would be a prior case management phone hearing, as there is currently under the Rosewell inquiry procedure, to decide which issues would take place by cross-examination and which would be a virtual round table. For example, as it has been the case the last couple of years in relation to 5-year housing land supply, where the cross-cutting issues such as approach to policy, generic points would tend to be dealt with through cross-examination, and the site-by-site, site-specific issues would be dealt with on a round table. I envisage it would also be done by live streaming. First question this raises is, would such a procedure be legally possible having regard to the legislative framework, both under the Town and Country Planning Act 1990 and the procedure rules? Well, in my view, the answer is plainly yes. The critical primary legislative requirement is in Section 321(2) of the Town and Country Planning Act. That requires an inquiry to be heard in public. Whether or not that requirement is satisfied would, of course, ultimately be a matter for the courts to determine on a review. And it's therefore notable that the the courts themselves consider that live streamed hearings are public hearings, and that's in the guidance as I set out in the second bullet on this slide. So the view of the court is, provided it's live streamed, it's public. The second point is whether the provisions in the inquiries procedure rules and the hearings procedure rules for inquiries and hearings to be held at a place and for certain parties to be able to appear at that place, whether that would be satisfied by holding at a virtual place through live streaming and an ability to appear through remote conferencing. Tim Mould QC, a very distinguished Silk, a Deputy High Court judge, he has written a paper for PIBA in the last few days, setting out comprehensively why those requirements would be met by a virtual place using video conferencing. For what it's worth, I agree with that analysis. So I don't see there's any legal impediment in terms of the statutory powers which would prevent this procedure. The next point is fairness, which is one of the considerations the inspectorate statement raised. As some will know, I and Chris Katkowski and others, including Matt Henderson, who's on this panel, we wrote a paper setting out the relevant principles in relation to the law of fairness and concluded that the law in relation to fairness could be satisfied, save perhaps in the most exceptional cases, by a remote procedure during the current crisis. Broadly speaking, the first principle is common law fairness. The case law is clear that common law fairness is circumstances specific. It doesn't have any rigid requirements. And in particular, there's no fixed right to an in-person hearing under the common law principles. We conclude that the circumstances specific analysis of what fairness does and doesn't require would include consideration of the current pandemic and the fact that a in-person hearing is currently impossible. That's plainly a relevant circumstance. And also we conclude that the fact that an in-person hearing or inquiry might be even better isn't relevant. The case law is clear that the focus in relation to whether a procedure is fair is whether that procedure would be fair, not a comparison with other procedures. And critically, we consider that at least in most cases, save in the most exceptional ones, everybody can be provided with equal access to a remote procedure. 95% of households currently own a mobile phone, and the technology, subject to appropriate instructions, the technology is sufficiently user-friendly. The European Court of Human Rights case law is relevant because the second limb of fairness is Article 6 of the ECHR, which imposes European obligations relating to a fair hearing. And it's notable that the ECHR case law includes the case on this slide, in which a prisoner brought a civil claim whilst in prison. He was not given an in-person hearing, but nor was any technological solution given. It was dealt with without a hearing. And the court held in this passage that hearing the applicant didn't have to take the form of an oral hearing in court in person. A technical solution such as remote conferencing by phone or video would have amounted to an oral hearing. So as far as the ECHR is concerned, a tech solution would suffice for Article 6. The second point that Pins raised was the public nature of inquiries. I've already dealt with how the courts take the view that the requirement for something to be in public can be dealt with by live streaming. In relation to the law on public participation, the key reference point is the Aarhus Convention, Article 6 of which relates to public participation in decisions on specific articles. And the relevant bit of Article 6 is paragraph 7, which is set out on this slide. The key take-home message is that the Aarhus Convention is not prescriptive as to how that public participation should take place. It could be in writing or at a hearing or at an inquiry. So there's nothing inherently inconsistent between Article 6 of the Aarhus Convention and a remote conferencing solution. So what are the next steps? Well, the inspectorate have indicated to PIBA that they're intending to pilot a small number of cases, principally the less complex inquiries using remote conferencing. They're proposing to use Microsoft Teams for that conferencing. There is, I'm told, a concern about security in Zoom for proceedings of this nature. The courts, I understand, take the same position, as indeed do the last but one cabinet meeting was done by Zoom. Yesterday's was done by Teams. So Teams is going to be the software they intend to use. They haven't yet set out any public statement about what number of inquiries will be included within this pilot, the selection criteria for inquiries to be included within the pilot for video conferencing, the timescale, when and over how long will it take place, whether there will be a review after the pilot before consideration is given to rolling out that pilot more broadly, the timescale of that review, and indeed thereafter the intended timescale for rolling out the pilot more broadly, and whether it will be wholesale to everything if the pilot is successful, or incremental case by case. So there's still a lot of questions that at least remain unanswered in the public domain. I expect that some of the answers to those questions may well be revealed shortly, so watch this space, and I and colleagues will make sure we update you when we hear more. I'll conclude finally with a report from one of my colleagues, Andrew Bias, who had a case management hearing yesterday in relation to a inquiry listed for the end of April. I know some of the other people listening on this seminar may have been involved in it. There was an application for the inquiry to proceed by video link, and the inspector took the view she would neither rule that in or rule that out. It was a matter for the inspectorate corporately. So it will be interesting to follow what happens in that case. Plainly, if it was due to start at the end of this month, a corporate decision by PINS on that inquiry is likely to be imminent, and that will be a good indication. It's a case involving 600 plus houses, so quite a substantial case. So the approach PINS takes that specific case, once publicised, will be instructive. Thank you very much for listening. I'm now going to hand over to Richard Turney to discuss the Planning Court.
Good morning, everyone, and thank you again for joining us. I can take this relatively briefly, the update on the Planning Court. Charlie's already touched on the question of the Lord Chief Justice's guidance. The position, as he said, is a clear steer from the Lord Chief that courts must continue, but taking all precautions to avoid unnecessary contact. And that's across the board, not just the Planning Court. And it's worth noting that there is some new guidance, there is a new protocol for telephone and video hearings, and there's even a new practice direction, 51Y, which was signed into effect at the beginning of this week. I think my big point that I'd emphasise, and I'll come on to the practicalities, but the key thing in planning is that time still runs. There's no alleviation of the time periods for bringing any proceedings in the planning world, even though obviously our ability to work is to some extent compromised. So just a reminder really, the limitation periods for the main business, the Planning Court, claims under section 288, section 113 local plan challenges, and section 118 DCO challenges. Those time periods are all set by statute. They cannot be extended by the court, however sympathetic the court might be to your circumstances. There are, by contrast, some limitation periods which can be extended by the court, but in practice rarely are, at least until now. So claims for judicial review and claims under section 289 are both capable of being extended, but in practice they rarely are, and therefore I would advise caution if you're thinking, well, current circumstances mean I should have more time. So the big question, and it's something that I know someone's already asked a question about on this, Paul Thompson has already asked this, what about issuing? Luckily, we have just got some guidance on this. The Admin Court Office and the Fees Office are closed. The consequence is all claims must be lodged electronically. And many of us might think about time too. The Planning Court is behind some other elements of the court service in dealing with matters electronically. You can now send an email to file your claim. File by email, the issue date will be the date that the email was received. You, in terms of fees, either paying by PBA account or undertaking to pay by cheque within 7 days and posting a cheque to the court. And there's a requirement to lodge an electronic bundle and some guidance given on that. I would just add to that that in the past 24 hours, we've made some specific inquiries to the planning court and the planning court lawyers, and the advice from them in 2 specific cases, I wouldn't take it as being part of the general guidance, but their advice was the electronic bundles you file now could be simple, and following resumption of normal business and the opening of the court office, you could send a full bundle at that point. So think about whether you might abbreviate what might otherwise be a very substantial electronic bundle. But filing by email is the key point. I just add some proceedings still need to be served before issue. So for example, section 289 needs to be served and the normal service rules apply. Filing other documents, again, file by email and pay fees if it's necessary to pay a fee by cheque or through the PBA system. And the email address for non-urgent business is set out there. I'd advise you look at the most recent guidance, which has been publicised by the Administrative Court, and we can provide that to you if you need it. So what are the key procedural tools for getting on with business? I think, first of all, time limits. In CPR 3.12, the court obviously has a broad discretion to extend time limits outside of those statutory limitation periods. And that includes, of course, adjourning hearings and also holding hearings by telephone or other method of direct oral communication. And I'd also note CPR 2.11 on extending time by written agreement. I've just put a slide here on adjournment on health grounds. The courts historically have been very slow to adjourn matters or extend time substantially on health grounds and require quite a high standard of medical evidence. In circumstances where people are self-isolating on advice, and that may prevent them from participating in court proceedings, but also prevent them from getting a doctor's letter to confirm their unavailability, then I suspect the court are going to take a more liberal approach. But perhaps the point is less relevant in circumstances where matters are proceeding generally by way of telephone and video. So video conference is already dealt with under the civil procedure rules, and the specific provision made, particularly in Practice Direction 32 Annex 3, which gives detailed guidance on the use of video conferencing. There is further guidance recently been issued in respect of that, and that's all contained in the hyperlinks that I've put earlier in the slides. So new practice direction, as I've already mentioned, practice direction 51Y, allowing for hearings to take place in private where broadcast of phone and video is not possible. That is a key tool for the court. At the moment, the technology the court using is not capable of webcasting, and the consequence is that hearings are technically taking place in private unless they are being broadcast through a phone into a courtroom, presumably in many cases an empty courtroom. So the court generally, in practice that I'm aware of over the past week or so, has been directing that the hearings are taking place in private, but making arrangements for press to be joined to video and phone hearings, and providing also for the recording of hearings so that members of the public could listen to the recording later if so required. And I've noted there the key guidance in the new protocol issued last week. Planning court timescales. As you will be aware, there are target timescales for significant planning court claims, and they are targets. There are no sanctions for failing to meet those. The planning court has been increasingly efficient in recent years in getting through business, and things have been coming on quite quickly. But at present, 2 key points to note. First of all, Most planning cases will give way to urgent business if the court is under pressure. And remember that many of the planning judges will also be dealing with urgent matters in the Queen's Bench list or the admin court, and therefore they may not be available to deal with planning matters, and they may well fall onto a back burner. The second point to note is that the court office is working at a hugely reduced capacity. And from the guidance I have seen, new matters which are being issued are simply not being processed. And therefore, at some point, there will be significant delays in the disposal of business in the planning court. So the experience so far, the current guidance and practice is that the listing office or the judge's clerk will contact parties, that should say close to the hearing date, to make arrangements for matters to proceed. So where things are already in the list, expect to hear from the judge's clerk and expect that to be a proposition that the hearing will go ahead. Planning hearings have been proceeding remotely from each of the main court centres. Telephone and video hearings have already taken place using a number of different technologies. The court is not prescriptive, and if the parties are able to volunteer appropriate technology, they seem to be receptive to it. And as I've noted already, authorisation to record has been granted in certain cases. So just by way of final comment, I would say, key thing, note that the timescales for filing claims has not changed. Filing has gone electronic, which will make life a lot easier, but expect that when you file new proceedings, that they will be sitting in an inbox for potentially weeks to come, and they may not be dealt with in the timescales that we've all become used to. For hearings that are already listed, expect them to go ahead by way of remote conferencing, telephone or video. I'm going to hand over to Anjoli now.
Thanks, Richard, and hello, everyone. I'm talking today about keeping planning permissions alive during the COVID-19 crisis. Essentially, that means I'll be covering issues surrounding the effects of the current situation on time limits for the commencement of development and for the submission of reserved matters applications, and also the effect on Section 106 obligations and community infrastructure levy payments. I'm just going to start off here with an introductory comment that actually there are a number of real problems starting to emerge with these issues already, and it's formed a lot of what we're hearing from clients. However, despite this, and it's perhaps surprising, none of these issues that I'll discuss have been the subject of any new guidance or legislative change by the government so far. And they haven't been touched on in either the Chief Planner's letter, which Charlie mentioned earlier, or in the Local Government Association's recent advice to local authorities. It is reasonable to think that the next planning-related change, where change is coming from the government, will be on one of the issues I'll be talking about, particularly on the issue of time limits. So starting with time limits, it's useful to quickly go through the relevant law in England. I note that the position is different in Wales. I've set out on the screen the time limits set under sections 91 and 92 of the Town and Country Planning Act, which will apply to every permission unless the local authority has set their own different time limits. Now, in relation to amending planning permissions, many of you will be familiar with applications under section 73. However, importantly, subsection 5 of section 73 explicitly states that such amendment applications cannot be used to amend these time limits. It's also relevant to note that time limits also can't be amended through the section 96A applications for non-material amendments procedure, because plainly time limits are not a non-material matter. So it's clear that within the current legal framework, time limits are strict and you can't change them. Of course, the purpose of this system is to encourage developers to implement their permissions promptly and to bring land onto the market. However, this system doesn't work if, for reasons such as the current climate, developers can't implement properly for reasons outside of their control. And the problems that will arise in the COVID-19 crisis are obvious. There are issues of commercial viability for developers and shutdown of construction sites. There are also issues with staff shortages and challenges associated with remote working, both for an applicant's planning team, for example, in putting together reserve matters applications, and also for local authorities, for example, in discharging pre-commencement conditions. And it's clear that the outcome from these problems is the risk that the planning permission will be lost. So turning to possible solutions, before simply saying that we need to wait for the law to change, which may take time, it's useful to explore whether there are any creative solutions within the current legal framework. And I've got a few suggestions here. First, quite simply, a developer could commence development as soon as possible and within the time limit. Of course, this will not be appropriate in every case, but parts of the construction industry are still active, and this might be a feasible option if, and it's a big if, it can be done in a safe way for workers. It's important to remember that in order to commence development, you only need to carry out what's called a material operation on site, and the test for this is not high. Second, where it's necessary for conditions to be discharged, use can be made of the deemed discharge of conditions procedure, whereby if the local authority doesn't respond by a certain time, the conditions are deemed to have been discharged. But it's important to note that this procedure is subject to a number of exceptions, which does make it less useful in practice. And third, in relation to reserve matters applications, it is likely that only actual submission of the application is required by the deadline. Validation by the local authority or even a decision on the application is likely not to be required by the deadline. So if you are in a position where you're approaching a reserve matters application deadline, it would be useful to absolutely prioritise the time limit and simply submit as full a reserved matters application as possible in time. However, the only real effective solution will be for the government to pass new legislation to create a separate application to extend time, or to create an automatic extension for all planning permissions. Now, this is not something new to us. A separate mechanism to extend time limits was introduced in 2009 in response to the last recession. And there are whispers that this is something the government is actively looking into at the moment. So this is very much a matter of watch this space again. It's interesting that very recently, within the past few days in Scotland, the Scottish government has now introduced an automatic extension to all permissions that are going to expire within 6 months. And that may be something that's done here in England too. Moving on to Section 106 agreements and possible problems of having to meet ongoing obligations when it's no longer commercially viable due to the COVID-19 situation. It's hopeful that such situations won't arise en masse, because usually payments under Section 106 obligations are triggered by active or positive events, for example, occupation of X number of dwellings. So if such payments have not been triggered yet, it would be possible for a developer to cease work on site and not to incur or trigger any further payments. However, clearly problems will still arise where payments have already been triggered, and issues will arise as to the overall quantum of payments and viability. In particular, as I've set out on the screen, it's likely that issues will arise as to early and late stage viability reviews and affordable housing, particularly in London under the London Mayor's requirements, where a developer hasn't completed as many units as was originally envisaged. In terms of solutions where these problems arise, frankly, there is no easy solution right now. The existing routes available for renegotiation and modification of Section 106 agreements, and that's either voluntary negotiation at any time or an application to the local authority under Section 106A after a period of 5 years, are dependent to an extent either on the consent of all the parties or the discretion and willingness of the local authority. clearly these existing routes forward are not easy solutions, but they may be useful where viability and deliverability are genuine concerns and where the local authority is willing, particularly if it might have an impact on the delivery of a 5-year housing land supply. There is potential if housing delivery rates do start to seriously stall, that the government may issue guidance on renegotiation of Section 106 agreements, or introduce a mechanism for relaxing affordable housing contributions. Again, this was something that the government did introduce in the last recession. But it is likely, I note, that if this does happen, it's something that will happen further in the future and not something that will happen imminently. Finally, turning to community infrastructure levy, this probably does cause and will cause more of a problem than Section 106 agreements, because payments will become due once development has commenced and as time passes by incrementally. Where payments have been triggered, either for the whole development or for a particular phase of a development, again, unfortunately, there's no perfect solution within the current legal framework, particularly given the strict way in which these SIL regulations are drafted. There is an exceptional circumstances relief in the SIL regulations, and as I've set out on the screen there, the planning practice guidance notes do helpfully refer to viability expressly as one such exceptional circumstance. And there's also the possibility for a charging authority to amend their instalment policy to set out payments in further time periods. However, both of these options are forward-looking. They can't be applied retrospectively to payments that have already been triggered. So perhaps it's not overly useful for all such problems that will arise. So at the moment, the best solution of a bad bunch really is for payments which have already been triggered, is probably for the charging authority to agree not to use their wide range of enforcement powers against payments not made on time, and for the parties to agree a payment plan going forwards. Now, obviously, again, this depends on the willingness of the charging authority, but there may be such willingness to make an agreement in circumstances where viability and deliverability is genuinely in trouble. Again, not a perfect solution by any means. And again, we are going to have to wait for legislative change in order for there to be effective solutions to deal with these issues. And so just to briefly summarise, as I've set out, there are real problems arising as to time limits, Section 106 obligations and SIL payments due to the COVID-19 crisis. And I've talked through some of the suggestions as to ways forward within the current legal framework. However, these are not perfect solutions, and real, proper, effective solutions will only come through changes in guidance and legislation. We've seen that the government has moved quickly already in introducing some planning-related changes, and it may be that the extension of time limits is something imminently next on the agenda. As I've said earlier, it's very much a matter of watch this space at the moment. I'm going to pass over to Matthew Henderson now, who will be discussing one of the planning changes that the government has already swiftly made.
Thank you, Anjoli. So my talk today is about COVID-19 in terms of shops, restaurants, cafes and drinking establishments. Two topics. The first is about the new temporary permitted development rights for restaurants, cafes and drinking establishments. And the second is the written ministerial statement on delivery restrictions. And the context for both of these issues is the closure of non-essential shops and the significant increase in people shopping for food and essentials. Some research for the week ending 17th of March showed an additional 15 million customers in supermarkets and increased average spend. So turning to the first of those topics, which is the amendment to the Town and Country Planning General Permitted Development Order. So this amendment came into force on the 10 a.m. on the 24th of March. It had two effects. The first effect was to insert a new Class DA, and I'll come on and talk about that in a moment, but in short, that's a new time-limited temporary change of use. And secondly, to amend Article 4 to prevent local planning authorities or the Secretary of State from removing the new Class DA in respect of certain areas. So then the new Class DA, what does it consist of? There's effectively 4 parts to this. Firstly, it's a change of use of a building or any land within its curtilage. So it doesn't include any operational development. It's a change of use from either Class A3 or Class A4 within the use classes order, or a mixed use within one of those classes. Or the 4th and final option is from a drinking establishment with an expanded food provision as defined in Class AA of the General Permitted Development Order. And it's from any of those classes to use for the provision of takeaway food. What does that mean? Well, paragraph D8.2 defines provision of takeaway food as includes any use for any purpose within Class A5, and any use for the provision of hot or cold food that has been prepared for consumers for collection or delivery to be consumed, reheated or cooked by consumers off the premises. So the important thing here is the breadth of possible activities which are included. And then finally, the time limiting period is between the 24th of March 2020 and the 23rd of March 2021. So that's giving a full year. Interesting because it goes beyond the 12 weeks, which has been in the government's messaging recently, and it suggests either an expectation that this will last for longer than we're being told at the minute, or a flexibility for businesses to get themselves back up and running over a prolonged period of time. Turning then to the conditions on this new class, there is in fact only one condition in the sense that we would usually see it, and that's the first bullet point which I put on the slide. So the developer must notify the local planning authority if the building and any land within its curtilage is being used or will be used for the provision of takeaway food. A few points to note about this. The purpose appears to be quite straightforward, and it's so that local planning authorities can keep a track of the premises which are relying on this new class. Importantly, it's not a prior approval process. It's entirely separate to the prior approval process which we're used to under the GPDO. And in actual fact, the requirements appear to be fairly minimal. There is, for example, no requirement as to timing. Prior approval typically has to occur before the commencement. Here, there's no such express statement, and indeed the language is being used or will be used, suggests that the change of use under this class may already have occurred before that notification is given. I think in terms of best practice, the advice should be to notify in writing and to notify before commencing the change of use under this class, and also for local planning authorities to acknowledge that notification if at all possible. The rest of the conditions, I've given the relevant parts to the second and third bullet points. So the second bullet point, this is the clarification that there's no effect on the use class, which the it's not required for the resumption of normal use under there, but it's clear anyway. And then the third bullet point, this provides for the automatic reversion back to the previous use, either at the end of the relevant period or if earlier when the developer ceases to provide takeaway food. So tying together with the time limit, which I talked about on the previous slide. One issue to highlight here, which has cropped up, is in respect of conditions. And Article 3, which prohibits anything in the order from permitting development which is contrary to a 90 Act. So in some circumstances, and this is in particular for shops which are operating under planning permissions from before 2005, then they're likely, or they may have a condition which excludes the use of the premises for takeaways. Now, Class DA would not allow that to be overridden, that condition would remain as it is now, and Class DA couldn't assist in those circumstances. And finally, the only other thing to bear in mind about Class DA is it doesn't deal with other issues, for example, what the terms of any lease of the premises are, or licensing in terms of the provision of late night refreshments. So turning finally then to the written ministerial statement, the context to this is well known. I've set it out there, I won't dwell on it. NPPF Power 55, the fact that enforcement action is discretionary, and that's reflected, of course, in the statute, section 172, the need for it to be expedient to issue any enforcement notice, and similarly section 187A in terms of planning conditions, the discretionary power there. So what does the WMS say? I've picked out some of the key points. It's directed at food, sanitary and other essential items. In its own words, its purpose is such that local planning authorities should take a positive approach to their engagement with food retailers and distributors, as well as the freight industry. So potentially quite wide reaching then, trying to encompass the whole of the supply chain and not simply being focused on certain areas. So just looking at the retail, but also looking at the supply chain earlier, warehousing, etc. What does a positive approach mean? Well, the WMS goes on in fairly strong terms, explains that local planning authorities should not seek to undertake planning enforcement action would result in unnecessarily restricting deliveries of food and other essential deliveries during this period. So a fairly clear steer there as to how local planning authorities should be drawing the balance when considering the public interest in these times. And I think that's reflected as well when we see slightly further on the fact that the government recognises there could be a temporary impact on local residents, but expressly refers to the need for this to be balanced by the significant public interest in ensuring that the shops are well stocked. And to be crystal clear, the WMS doesn't prevent enforcement action in respect of conditions around deliveries. But if a local planning authority were to take enforcement action, they'd need to be particularly careful about firstly considering the WMS and providing reasons for departing from it in the current circumstances, and it's best practice if that consideration is recorded in writing. And I think the final thing is this is something which has also been picked up by the Chief Planning Officer in the local in the latest circular, which Charlie referred to earlier. So with that, if I hand back now to Charlie for some Q&A, and hopefully you'll all be able to see us in a moment.
Thanks, Matt, and I hope you can all hear us. You'll surely see none of us, I'm pleased to say, are in our pyjamas. A few questions. We've got, quite remarkably, 65 questions now. We're clearly not going to have the time to deal with each and every question or anything like that now. What I propose to do is we'll put together a general note in the next, well, hopefully later today, and if not, within the next 24 hours, covering all the themes dealt with by the questions, and also hopefully dealing with each and every question now. In the time we've got remaining, I'll rattle through a few questions and themes that have come up relating to my subject, and then I'll pass to the other speakers. Somebody asked about Section 106s and whether a inability to seal a Section 106 could hold up a planning permission. There was a rather interesting LinkedIn post by Chris Bowes of CMS a few days ago, suggesting actually that the challenges relating to getting a 106 executed at the present time may be an exceptional circumstance justifying a Grampian-style negative planning condition, saying no development to be commenced until a Section 106 is executed. It seems to me that's quite sage advice. That might be one way of cutting that corner. Lots of questions about PIN's approach. What sorts of cases can proceed without a site visit? A paradigm case might be an appeal concern where the main or only issue is viability in the context of affordable housing provision, for example, where nothing really turns in the site. It's clear from the written reps example I gave in my slides that PINS are taking a fairly restrictive approach to the kinds of cases that can be dealt with in writing. The written reps case I'm dealing with is really pretty straightforward, at least so my clients say, and PINS are not entertaining a site visit. Somebody mentioned that the inspectorate have in their case downgraded a hearing to written reps, but are then not accepting any further written reps on points which would have been dealt with or elaborated orally, and have asked about that. That's dubious to say the least. My suggestion there would probably be send in the points that you would have made orally, and then if PINS don't take them into account, possibly there may be a grounds for challenge, depending on the circumstances, but don't send them in and sort of see who blinks first. Site notice and consultation came up. Is there an issue in relation to the requirement to serve site notice? Is there an issue in relation to public consultation given the current lockdown? I don't think personally there is, not least because people are being advised they can go outside for 1 hour a day. It would seem to me to be sensible, particularly in a potentially controversial case, to perhaps be a bit more expansive as a local authority in relation to consultation and notification than you would normally do. So maybe allow for a longer period than the statutory minimum, maybe direct mail shoot more people than would normally be sent a letter of notification, so as to avoid or minimise the risks of anybody not finding out who would have done. But I don't see an in principle obstacle in relation to that. Would the postponement of hearings and inquiries risk decisions being held up where everything has happened apart from the inspector's decision letter? Well, no, it shouldn't. Most, if not all, planning inspectors who do Section 78 appeals work predominantly from home when they're not out on inquiries anyway. So it shouldn't hold up a decision letter unless, of course, the inspector or members of their family are unwell. But that would be the case anyway. Judicial review risks in relation to planning committee hearings done by tech. How real is the judicial review threat? By and large, I expect the planning court to be fairly sympathetic to procedures that have been dealt with by technology, simply because that's what the court is doing, and frankly that's what we need to be doing to keep the world going round until such time as we can all meet in person. So I'd expect the starting point of the planning court would be they would take some convincing that a technological procedure was either prejudicial or unfair. And a related question about council constitutions, and would they need to be amended to deal with tech solutions once the regulations that are, by the way, I think expected from government imminently in a matter of days, once those regulations are out. It will obviously depend upon the nature of the constitution, what the wording, but if it uses terms like place and in public, etc., then the points that I mentioned before in relation to the inquiries procedure rules and the Section 321 would apply equally. Final point, what about older people and tech? Obviously, this is a very sensitive issue. My own view, for what it's worth, is I don't see that there's an in principle unfairness with expecting older people to use technology to participate in inquiries. As I said before, pretty much everybody can be taken to have access to a telephone and some kind of technological solution unless they provide evidence to the contrary. I think you can start with the presumption that people have the equipment. As today's seminar shows, you get sent a link and you click on it. It's not really that difficult. Famous last words. Now, obviously, the whole thing will go kaput. I've said that, but it really isn't that difficult. People can be taken to be able to follow instructions, just as to how to find a town hall, which committee room to go to, how to follow the procedure. Yes, it's a difficult learning curve. Yes, it's not as easy as doing it in person. Is it truly unfair? I don't think so. And I would add this too, that actually technological solutions may well enable a more diverse pool of people to participate in proceedings than has been the case traditionally at inquiries. People with children and childcare commitments during the daytime who can't so easily attend, people who've got jobs who can't get half a day off work, people with mobility issues. So actually it may have a silver lining compared to in-person inquiries. Those are some thoughts. As I said, we'll deal with all the questions either through a general note or through specific answers shortly. I'm going to hand over to Richard for any comments you have on particular questions relating to yours, and then perhaps Richard, if you hand over to Anjoli and Matt and deal briefly with any questions that relate to your topics.
Thanks, Charlie. I've just seen some questions come up about the slides and the audio recording. They will be available afterwards later today, so you can catch up on things then. Just a few points raised on planning court matters. Paul Wakefield made a very good point about service. Many local authorities and others don't accept service electronically. The answer, I think, is to pop it in the post and rely on the service provisions, but obviously you need to allow time for that. So it does suggest you need to move a bit quicker, particularly on those cases where you have to serve before filing. A question was raised about the claim forms not being sealed and serving a 288 within the statutory timescale. I think it's worth remembering that the service provision in that requires you to serve before the end of the statutory time period for issuing the claim, it is set out in a practice direction. It is not part of the statutory limitation period, so you can extend that period by court order, and you may need to. My suggestion is once you've filed your claim, send it through an appropriate means to the parties, and at that point they would have very little complaint if they said, well, you haven't formally served me with a sealed claim form in the relevant time period. And finally, a question about delays at the admin court. At present, they're working through hearings, but my understanding is they are simply not dealing with new business, except urgent business and business which is related to the current crisis. I don't know whether that will be remedied and how quickly it will be remedied. The word from the court yesterday did not suggest that they were in any hurry to open their email inbox, which is presumably now full of new claims. So I think we can expect some considerable delay, even if things are moving at the moment. I'll hand over now to Anjoli, I think.
Thanks, Richard. For some reason, my video isn't working, and I promise it's not because I'm in my pajamas, but you can just hear my audio instead. Just a couple of questions. I saw somebody's made the quite clever suggestion on pre-commencement conditions as to whether instead one route around it might be to apply to amend these so that they're not pre-commencement conditions, but just conditions that you have to comply with after commencement. And yes, actually, I think that's quite a clever suggestion. You can amend a condition to say that it's not properly a pre-commencement condition, and it doesn't go to the heart of the matter. So that certainly is another route that one could look at. And another issue that was raised was on the issue of prior approvals and permitted development, as to whether the time limits should be extended for those too. Absolutely, yes. The slightly thornier issue with those is that some of these permitted development rights, for example, the office to resi, require completion by a certain date, not just commencement. So that would obviously have to be something that the government factored into their extension of time limits, and if there's an imminent problem on the horizon for you in particular, it might be that that's a discussion to be had with the local authority as to possibly being softer on enforcement before the government extends these time limits appropriately. I'll just pass over briefly to Matt now to deal with any questions on his topic.
Thanks, Anjoli. So I think looking at across the board, broadly three issues. Firstly, in respect of conditions. So just to repeat a point that I made earlier, but which may not have been entirely clear with the audio. If you have an existing planning permission which has a condition on it, and the effect of that condition is to prohibit the use of the premises as a takeaway, then Class DA is not going to be available and open to you here, and that's by operation of Article 3. Of the 2015 order, which prevents anything in the later classes being used to override a condition on a grant of planning permission under Part 3 of the 1990 Act. Linked to that, somebody's asked about conditions when you go back to the normal lawful use. in my view, the conditions which applied then previously to that normal lawful use would continue to apply, and there's no reason why they would be disapplied by this temporary period. And then finally, picking up about enforcement action and whether or not a notice is issued. I think starting from the usual position on conditions under the General Permitted Development Order, they form part of the permitted development right. You need to comply with them. See Keenan, more recently Westminster, both in the Court of Appeal. But any difficulty here in respect of notification, I think, is one which falls under the second part of my talk and the WMS, and about local planning authorities taking a proportionate and reasonable approach. Thinking about what the failure means in real life terms and whether any sort of enforcement action is necessary there. Slightly different question as to whether you can benefit from Class DA anyway in respect of that, but I think leave that one slightly open and point back to Keenan and Westminster.
Thanks, Matt, Anjoli, and thank you all. We've had, I think at one point we hit 783 participants. For those who have dubious music taste like me, that's about the same as filling out the Shepherd's Bush Empire, I think. So there we go. That's a claim to fame, if nothing else. As I said, we'll provide a general update very shortly in relation to all those questions. And please watch this space for further updates. We'll keep you posted when we have any more news relevant to our topics, particularly the practice of the inspectorate, where I expect we'll hear some updates very soon. I'm looking at doing a mock inquiry and recording it with Zach Simons, Kate Ollie and Chris Katkowski, and some planning witnesses to test how it works. And we're going to make extracts of that available. That will be the next few days. So please keep in touch, stay well, and I hope to see you in person before too long. Thank you all very much. I'm now going to conclude the meeting. Thank you very much.